Today, we're diving into a critical and honestly, a pretty hidden breakdown in our justice system. We're talking about how family courts, the very places that are supposed to be a safe haven, are often failing to protect victims of domestic abuse, even though we have human rights laws designed to do exactly that. Wow. Just let that sink in for a second. That's from a survivor of domestic abuse, and it reveals a terrifying reality. What if the place you run to for protection actually makes things worse? What if it becomes a source of even greater trauma? So, how on earth does this happen? Well, to really get our heads around it, we have to look at the system itself. For victims, family court isn't always a refuge. In fact, as we're about to see, it can be the exact opposite, a truly dangerous system. Research is crystal clear on this. The moment a victim tries to leave and separate is when the risk to their life escalates dramatically. And abusers often weaponize the court proceedings themselves, using them as a brand new stage to continue their coercion and control, not just over the victim, but over their children, too. And this is where it gets really chilling. This slide breaks down the mechanics of that danger. You see, perpetrators can use the legal process itself to harass and intimidate their victims. In some cases, courts actually grant abusers access, which has led to the most tragic outcomes you can imagine: homicides of mothers and their children. And because all of this happens behind the closed doors of family court, there's very little public scrutiny to hold the system accountable. So all of this leads to a massive, glaring paradox. We have these powerful international human rights laws that were specifically designed to prevent this exact kind of harm. So why aren't they working where they are needed the most? What's going on here? Well, a huge part of the problem is something experts call the implementation gap. It's a fancy term for a simple, frustrating idea. A country can sign all the international treaties it wants, but if those rights and principles aren't actually applied and enforced in its own courts, they're just words on a page. And this gap, it's especially wide when it comes to the rights of women and children. This slide really gets to the heart of a long-standing issue called the public-private divide. Think of it like this. Human rights law is pretty good at policing what the government does out in the open, in the public sphere. But it's always struggled to reach inside the so-called private world of the family. And this creates a kind of legal blind spot, a place where victims of domestic abuse are often left completely unprotected. Now, to understand just how confusing and dysfunctional this system can be for a victim, we need to look at this powerful model developed by a researcher named Marianne Hester. She calls it the three-planet system, and it is a perfect analogy. Hester's three-planet model shows that victims aren't dealing with one single justice system. Nope. They're actually navigating three separate systems that might as well be on different planets. They don't talk to each other, they have totally different priorities, and they create this confusing and incredibly dangerous trap. I mean, just look at this impossible situation. First, the victim lands on the criminal court planet. The message there is clear: you must not have contact with the abuser for your own safety. Then she goes to the child protection planet, and they say the same thing, sometimes even threatening to remove her kids if she doesn't protect them from the abuser. But then she gets to the family court planet, and it gives her the complete opposite order. You must allow contact. It's an impossible bind. So you have to wonder, why is the family court on a totally different planet? Well, it's often driven by what many call a contact at all costs culture. This mindset has been really heavily influenced by fathers' rights movements, which, have been very successful at using human rights language, like the right to a family life, to argue for access. And this often means a parent's right to contact gets prioritized over very clear, very present safety risks. And look, this isn't just a theory. We've got the receipts. Groundbreaking research from Professor Shazia Choudhry gives us the cold, hard data, showing exactly how this imbalance plays out in actual courtrooms. Okay, this chart is just staggering. Let it sink in. In cases involving domestic abuse, the father's right to family life, which is a qualified right, meaning it can be limited, is brought up in nearly half of all cases. Now compare that to the victim's absolute rights, like the right to life and the right to be free from torture, rights that should never be limited. Those are raised less than 10% of the time. The whole system is fundamentally tilted. And here is the human cost of that data. You have a survivor who sees the injustice plain as day. She asks the right question: what about my right not to be abused? But her own legal team, her own barrister, doesn't even pick up on it. Her most fundamental human rights were simply ignored, made invisible. The research also dug up these really clear judicial double standards. As one survivor noted, when a father shows emotion in court, the judge sees a hurting parent who just misses his kids. But when a mother shows the exact same emotion, she's labeled unstable, and it's used as a weapon against her. This kind of bias directly shapes the outcome of these cases. This quote just says it all, doesn't it? Victims walk into the system believing it's there to uphold their rights, only to have that belief totally dismantled. They come out feeling more powerless than when they went in. So, after seeing the scale of this problem, the critical question is, what can we do? How do we even begin to fix this? Well, the good news is, the research doesn't just point out the problems. It also points towards some very concrete solutions. Okay, the path forward isn't simple. It's going to take a massive, coordinated push. And it really has to start with education. We're talking about specialist training for absolutely everyone involved, from judges and lawyers to court-appointed experts, on both human rights law and the real dynamics of domestic abuse. At the same time, governments need to step up and actually monitor their own courts. And crucially, women's organizations need to reclaim the language of human rights. But at the end of the day, all of this points to one big thing. We need a profound cultural shift within the legal world itself. And that leaves us with this final, really important question to think about. The research suggests that human rights aren't just abstract ideas on paper. They're brought into existence when people speak them, when they claim them. So if the current script is failing so many people, it falls on all of us, lawyers, judges, lawmakers, and citizens, to demand a new one.